Hi, I'm attorney Michael Doan, owner of the Oceanside division of Doan Law Firm. I have been exclusively practicing bankruptcy for nearly 30 years, and I am a certified bankruptcy specialist by the American Board of Certification in Consumer Bankruptcy Law. Rest assured, you are in good hands with our firm, having filed nearly 50,000 bankruptcy cases. You're receiving this video because we have pre-qualified you for Chapter 7 based upon the intake sheet you recently provided us. Chapter 7 is the quickest, cheapest, and most commonly filed bankruptcy chapter. It is also the fastest and most effective chapter in improving credit scores. Starting today, you would never make another payment again to any of your creditors. Most Chapter 7 bankruptcies generally take about 3 months to complete from start to finish. Upon discharge, creditors are wiped out forever. Judgments are deemed void, and your credit reports must reflect zero balances on every account. And despite those myths that bankruptcy destroys credit, most of our clients actually end up with better credit scores after bankruptcy than before, averaging around 650. And from that point, it generally takes about 1 to 2 years to rebuild credit back into the 700s, which is considered perfect credit. You will also likely qualify for bankruptcy auto financing the day your case is filed and receive credit card offers once you receive your discharge. So not only will Chapter 7 give you a fresh start and remove all your debt, but it will provide you with new opportunities for future credit, including buying a house in 2 years. This video will describe in detail Doan Law's trifold services for Chapter 7 bankruptcy cases. Please pay close attention to all segments of the video and feel free to rewind and repeat at your leisure. Chances are this video will answer most, if not all, questions you may have in seeking Chapter 7 bankruptcy relief. After watching the video, I will personally meet with you to further discuss your case and answer any other questions you may have. While a lot of our clients feel they need to tell us a story or provide some other explanation as to why they qualify for bankruptcy, that is not required. Instead, qualifying for Chapter 7 bankruptcy is rather mechanical in nature. As long as you generally satisfy 3 main criteria, you will receive a Chapter 7 discharge as a matter of course. And in your case, it appears you satisfy these 3 main criteria. First, all your assets appear to be protected under California law. That means nothing will be taken from you and you will keep everything you own. You will keep your vehicles, bank accounts, retirement accounts, jewelry, and all other personal property. If you own real estate, we have also determined that is protected as well. Second, it appears all your debt is dischargeable. You will never need to make another payment on any of your unsecured debt ever again. This includes credit cards, personal loans, medical bills, collection accounts, repossessions, SBA loans, other business loans, and most other non-priority unsecured debt. While there are some exceptions to debts which can be discharged, they primarily consist of student loans, support obligations, recent taxes, and other government fines or penalties. If you have any of these non-dischargeable debts, I will go over those with you. Further, if you have a house or a car that is secured and you're making payments, you will need to keep making those payments since they are secured and can repossess or foreclose if you stop paying. Third, and finally, it appears that your income passes the means test. The means test is a mechanical test created by Congress in 2005, which has little to do with reality, but can make or break any Chapter 7 bankruptcy case. Basically, your average monthly income for the previous 6 months prior to filing is compared to the median income for where you live. If it's less, you pass. If it's more, we go to stage 2, and then we deduct living expenses based upon IRS tables. If you still don't pass the means test, they can dismiss your case or give you the option to convert to Chapter 13. Now, Chapter 7 is the preferred chapter since nothing needs to be paid back, and which is what we want to do for you. Chapter 13, on the other hand, requires a 3 to 5 year payback period of monthly payments determined by subtracting your reasonable monthly expenses from your monthly net income. So, passing the means test is extremely important for Chapter 7. So the good news is you just satisfied the 3 criteria for a Chapter 7 discharge. In doing so, we can offer you our trifold bankruptcy services. This consists of immediate representation before the bankruptcy is even filed, complete representation during the bankruptcy from start to finish, and continued representation after discharge in dealing with any rogue creditors and in rebuilding your credit. The first part of our trifold services consists of providing immediate representation from the date we are retained until the filing of your case, and it actually represents about 70% of our services. These services will consist of representation to your creditors and terminating their communications, asset planning, bankruptcy case preparation for filing, and other general legal advice in order to get your bankruptcy case filed. From the moment we are retained, you immediately stop paying all creditors and stop charging on all accounts. At the same time, creditors must end all communications with you due to the cease and desist letters they receive from our office. By law, creditors are prohibited from communicating with you once they are aware of our representation. Should any creditor call you, email you, text you, write you, or otherwise contact you after receiving our cease and desist letters, they could be subject to a $1,500 penalty per contact. The cease and desist letters are derived from the credit reports that we immediately obtain on your behalf from tri-merge credit reports and a public records search. Generally, there is no need for you to supply us with any creditor information. In the event you receive any contact from creditors after the cease and desist letters are sent, you would keep track on the call log sheets we provide you. Creditors are not free to break the law. For instance, if a creditor contacts you 10 times after they get our letter, it could be liable for $15,000 in statutory penalties, actual damages, attorney fees, and costs. But for the most part, creditors are usually law-abiding and cease all communications since they don't like being sued. As such, you should have total peace of mind from the moment we are retained. But in the event you do receive communications, simply keep track on the call log sheets we provide you and we can sue them for damages. Now, in order to process your bankruptcy, you will have some homework which generally consists of 3 items: online worksheets, credit counseling, and documentation. The online worksheets will generally take 1 to 2 hours to complete and primarily consist of questions about your assets, your monthly budget, and other financial affairs. The credit counseling course can be done online or over the phone and generally takes about an hour. There's no wrong answers and you can come and go as you please. And if you're filing jointly, only one spouse needs to complete the course for the 2 of you. Finally, the documentation generally consists of 6 months of income, latest tax return, and asset documents such as bank and retirement account statements, vehicle registration and payoff, and real estate documents if you own real estate. It generally only takes us about a day to process your bankruptcy case once we receive everything from you. We'll then send you a draft of your case for your review. Most Chapter 7 bankruptcies are about 90 pages long, so it's a rather lengthy document. Luckily, most of the pages are legalese, and your main focus should just be on the data inside it. Now, you'll want to make any changes or corrections as needed since this is only a draft. We can update that later. And after you review your bankruptcy draft and make any changes, we'll schedule a signing appointment. At that signing appointment, I will thoroughly go through your bankruptcy petition and schedules with you, answer any questions you may have, and make those necessary changes and corrections for finalization of your bankruptcy. At that point, we will obtain your electronic signature so that we can file your bankruptcy electronically with the bankruptcy court. The hardest part is now over. The second part of our trifold services begins with the filing of your bankruptcy case with the bankruptcy court and represents about 20% of our services. Now, once your case is filed, the automatic stay is entered, which is a federal restraining order against all creditors on any actions against you. Any wage garnishments, bank levies, repossessions, evictions, foreclosures, etc., they all must stop. We will provide you with your case number and hearing date for the meeting of creditors. Now, with your case number, you'll be able to take your second bankruptcy course, which is called the Financial Management course. And just like that first course, it too generally takes about an hour and there's no wrong answers. The hearing date will be about 30 days after we file your case, but it does not require a physical appearance. Instead, we will meet with your bankruptcy trustee electronically from the convenience of wherever you are at. There is no court or bankruptcy judge involvement. The meeting usually lasts under 5 minutes and generally consists of you affirming everything in your bankruptcy petition and schedules is true and accurate. In over 99% of the cases, no creditors ever attend, and the meeting is rather boring and uneventful. Now, we will be representing you at the hearing just to clarify any issues that may arise. However, that's quite uncommon. After the hearing, you're essentially done. There are no more hearings or other requirements for you to complete. And about 60 days later, your discharge will be entered as a matter of course, and the case will close shortly thereafter. Now, in some cases, a creditor may violate the bankruptcy laws by trying to collect on their debt. If that is the case, we can pursue the creditor for damages. It is not uncommon for such violations to result in substantial awards for our clients, and those creditors must also pay our attorney fees as well. Just like those cease and desist letter violations worth up to $1,500 a call, you would simply let us know of any collection attempts and we can go after the offending creditors. The third and final part of our trifold services consists of credit rebuilding after discharge and is about 10% of our services. This involves accurate credit reporting, credit rebuilding, and pursuing any creditors that violate the discharge injunction. Now, once you receive your discharge, all balances on your credit report must reflect zero balances. Failing to report a zero balance can be cause for violating the discharge. Zero balances are important since they are about 1/3 of your credit score and derived from your debt to credit ratios. False balance reporting can also negatively impact your credit score after discharge. Now, we also have a credit rebuilding program to help you improve your credit score after discharge. As I said earlier, your credit score should reflect about 650 at discharge. But with the credit rebuilding program, your score can get back into the 700s in about 1 to 2 years. This is a 3-month program. It's free to all our clients and it takes about 15 minutes a week. We have had some clients rebuild their scores into the 700s in less than a year using the program, so it is strongly recommended. With the discharge will also come numerous solicitations from credit card companies for credit cards. Credit cards are good since they will actually help you rebuild your credit. You'll want to use these credit cards for monthly personal expenses such as transportation and food. As long as you pay the balance off each month, you'll incur no interest, you'll obtain higher credit limits, and you'll increase your overall credit score. So make sure to make positive use of the credit cards by paying off the monthly balance and avoiding any liabilities. Finally, as with the cease and desist letter violations and the automatic stay violations, our office is also prepared to go after any creditors that violate the discharge injunction. If any creditors contact you after discharge, let us know. Violations of the discharge subject the offending creditor to sanctions and attorney fees. Creditors must pay you money for any violations, and we will make sure of that. Now, what I have discussed are the most general aspects of every Chapter 7 case. Some cases are more complex than others. For instance, you might be filing jointly with your spouse. Maybe you're surrendering one or more vehicles back to creditors. Maybe you're removing a judgment lien from a house or trying to get money back from a creditor that garnished your wages pre-petition. Maybe you have higher than average monthly income or need to engage in asset planning or have non-dischargeable debt. While these and other issues are routinely dealt with in Chapter 7 cases, I will personally go over any such issues unique to your case. Finally, you're probably wondering what the total fees and costs will be for a Chapter 7. Most cases run between $1,500 and $2,900 in attorney fees plus costs. They depend upon the complexity of each individual unique case. Now, we will open your file and consider ourselves fully retained upon an initial $100 retainer deposit. However, all attorney fees and costs must be paid in full prior to filing your bankruptcy case with the bankruptcy court. This is because Chapter 7 is such a powerful bankruptcy chapter that attorney fees and costs are no different than credit cards, and they get wiped out just like everybody else. Therefore, you decide how long it will take to come up with the total fees and costs and when your filing date will be. While we can offer convenient monthly payment plans as low as $100 a month, the sooner everything is paid, the sooner we can file with the bankruptcy court. But remember, in the meantime, despite how long it takes, you are instantly protected from all creditor harassment and other communications. This is simply because our cease and desist letters prevent them from communicating with you before we file your case. Now, finally, if you have an urgent situation involving a wage garnishment, bank levy, eviction, repossession, foreclosure, pending lawsuit, or other emergency situation, we will need to act fast to get your case filed. Only the actual case filing will engage the bankruptcy automatic stay and freeze the action. And sometimes we can file what's known as an emergency petition, a bare bones filing, to immediately stop the creditor and then file the remaining paperwork at a later date. So now that you're familiar with the Chapter 7 bankruptcy filing process, the next step is to set up a free consultation and we can go over your case in more detail. Please bring a list of specific questions that you might have and be prepared to discuss what type of payment plan you would prefer. It will be an honor to represent you in your bankruptcy case, obtaining your fresh start, and rebuilding your credit.